back to the show. This is The Law Show on CL 650.
And welcome back to The Law Show. We're talking about wills and estates. It's been a fascinating conversation so far. We have Alyssa Lockhart, partner, McQuarrie Hunter in studio, along with Leah Donaldson. And before the break, we were talking about minor children in a will, and you set a trust that disperses the money over time. Mm-hmm. So before the break, you were saying, you know, you have some children that are fully formed and they're able to take on the responsibility of inheriting that money. Other kids, maybe not so much. But you alluded to the fact that you want to protect that money in case they get married at a young age and it doesn't work out. So give me some scenarios there.
Well, that's a really good scenario. That one in particular happens frequently. We have more and more blended families in our society, and we know that only can happen where there has been a failed relationship from the beginning. So we know that our children might be susceptible to living with or marrying someone that they would spend all of their money on, that they would invest in joint enterprises with, and that then they find they can't communicate with, that they no longer share interests with, for whatever reason. How do you extract the family money from that relationship if it has been placed into a joint venture that's growing, if it's been placed into a marital home that otherwise the child couldn't afford?
So if you inherit the money and you're young and you're married and you say this $500,000 is mine, and you don't put it into a joint venture like a home, then if you got divorced, you could say, well, that $500,000 is mine, right?
Great question for Leah.
Yes, so that's an excluded property provision under the Family Law Act. So if you were to inherit that money and keep it separate in a separate account and it's not in joint names, then under the legislation, that is yours alone.
But if you're a young person starting out and you need that money to buy your first home.
And you put it into a home in either your spouse's name or your joint names, there's a question right now about whether the court is going to allow you to maintain that exclusion.
So even if you get divorced and you say, hey, I brought in $500,000 here, I need to get that back. Now, can you write a letter saying, what do you do in those situations?
We would recommend that you document it. Well, the first piece of advice is to not do that, is to not put it into joint names. But if you're going to do it...
But people need money, and they've got money, so they want to use that money.
And if they need money, then they can risk it by putting it into joint names or their spouse's name, but know that at least they're getting the proper advice that they are putting it at risk by doing that, and so they can try to prepare documents to evidence what the agreement was at that time. Is that upheld typically? It depends on so many circumstances, and it's actually an area of the law that's still being determined, because the legislation seems to say, no, it's excluded, but there are circumstances in the way you can handle that money that the court's saying, well, no, we're not going to let you get away with saying that that's an exclusion. And
as time goes by, say you've been involved and married for 20, 25 years, the court might say, well, that money's to benefit both of you.
That's right. The chances of you maintaining the exclusion after that long are much lower than if it was a short-term marriage.
Okay. All right. So you have this trust for minor children when they get older. So how far can you stretch out that I'm going to give the money to my child 10% when they're 19? Right. So what do you typically advise?
Yeah, there's two notions at play here. One is to protect your child. One is to provide lessons to your child that they will find useful in managing a significant amount of wealth. The wealth that you have achieved over your entire adult life might become the property of your very young child if you die early.
All those years saving, and then they can blow it all in no time. Right.
So that's the one principle. We want to protect the child from themselves, essentially, and preserve the wealth for their entire adult life so that they can use it wisely.
That song, if I had $1 million, I'd be rich. Yeah. Well, here we are in 2017, and $1 million doesn't go far anymore. And you would never think that 20 years ago when that song came out that $1 million wouldn't be a lot of money. Right. So you get a 25-year-old kid that has $1 million, they think, I'm invincible. I'm bulletproof. I can go on forever spending this money.
And it's wasted very quickly on ill thought out investments or
depreciating
a business
assets,
without a plan, depreciating assets. Cars are a big depreciating assets. Clothes, watches, all of those things, they're lovely, but we pay a premium when we buy retail, and we end up with a lot of nice things that don't get us very far, perhaps. The other part of the question on how long can we draw that trust out, though, is the risk, I think, of trying to rule from beyond the grave. The goal here is that my child will not inherit $3 million from my life insurance policy and the sale of my property on the date that they turn 19 and not know how to preserve it for their own benefit and their own children in the future. The goal is not for me to say, and when you're 75, you can have $1,000 more. And when you pass away, then I want it all to go to your children. A lot of times clients will say, I just wouldn't trust my child with this much money ever. I want to hold it for the next generation. And I look at their child, a sweet little 10-year-old, and I think, how would you know that you won't ever trust this child ever? So I don't necessarily encourage clients to do the in perpetuity type trust where we're trying to make what is essentially single generation wealth last over multiple generations. And I think that's something that is also a function of the times. $1 million 20 years ago used to be a lot of money. $3 million is a fairly common sized estate at this point. Don't get me wrong. I see estates that are 400,000 in size all the time. But $3 million is not hard to do if you have life insurance and a property in the Lower Mainland.
Absolutely.
So when we look at that, that's single generation wealth. If you're trying to preserve that for the grandchildren and really try and set up almost an annuity type fund, you're looking at a different number than that. This money should be doled out, in my view, for most clients' children at very specific stages of their life, when they're ready for more money, when they've settled down with somebody that they absolutely do want to invest not only their time but their inheritance in. But we shouldn't necessarily be thinking that we have to hold it. We can, though, if we have a disabled child who will never be able to make wise decisions with money, who might always be susceptible to being taken advantage of by other people. We might want to hold that asset until they pass away and then distribute the residue amongst their children, or if they're disabled and won't have a relationship that creates children, then to our other children or to our grandchildren. But those are two very different purposes for extending a trust. Now,
Leah, your other hat is family law that you wear at McQuarrie Hunter. So I'll give that example again. That $500,000 comes into one person's, they inherit it, and then the partner is saying, well, we can really use that $500,000 to buy our dream house. Can that facilitate a divorce at that point?
It can, yeah. But what I say to people, and unfortunately, often I talk to them after, they don't come in and ask for family law advice before they get separated. So if you do get inheritance, it's a good idea to come in and talk to a lawyer who's going to know what happens if you do A, B, and C with that money. But I do say to people, well, you got your dream house and you were in a marriage, and sometimes the price that you pay for that is to have to give up some of that money. So I don't think that, the answer is to always keep everything separate. But I think to make informed decisions, it's important. And so, that's something that the will maker, when they're deciding how they're dividing their estate, they have to keep in mind that their children have spouses and they have no control over that spouse. They don't know what's going to happen in their relationship in the future.
So back to your point, you've lived your life and you were allowed to make your own decisions. And then your children are inheriting this money. And even though you might think that they're not ever going to be responsible, they still have to live their life.
Yes.
And so if they make poor decisions with the money that you leave them, that's what they decided to do.
It is. And some clients will say, I don't want a trust that carries until they're 30, because if they blow it at 19, then that's their own problem. And I think that, again, we have to look at the circumstances of each case. So every client is different. Every client knows their children, or if they're very young, we don't know what the children will be like. But the clients know how much money they're talking about. When we set up a trust, we're not withholding funds for purposes like education or the purchase of a first first house, or if a child were to bring me a business plan and say, hey, Mom, can I borrow this amount of money? Look at the business plan. It's a good deal, and I'll pay you interest. I might say yes, because that's good initiative. So will a trustee. You have to talk to your trustee, select a trustee that either knows the children very well or knows your values very well. What would you advance funds for? Mm-hmm. And what would you not advance funds for? So when you're gone, they can make that choice.
Now, Leah, 3 children, you can get a sizable inheritance of, say, $3 million. 3 children, let's say evenly $1 million each. Bob in the middle blows it all in the first 2 years, and then you've got 2 savers on either side, one older, one younger. Can they come back then and say, I'm broke, I have no money? Has that happened?
There's limitations on what claims you can make, but normally if you divide your estate equally among your children and then years later one has spent it, they don't have a claim to come back against their siblings and say, oh, I should have gotten more back then. They have to make the claim at the time they find out what they're actually getting from the will.
Have you seen situations where you have 3 kids, each get some take that small inheritance and parlay it into something big? Mm-hmm. Others spend it all on, fancy vacations and on cars, and then the other person just puts it in a...
Yeah, we've absolutely seen all of those examples, and sometimes in the same family. So it definitely happens. It's something I think I see all the time. When clients come in and we're doing an estate administration, one of the children will say, well, when this person passed away, this is what happened with the money in the family. And so it really affects the next estate administration going down. So I do hear those anecdotal stories from families.
Mm-hmm. And go ahead.
And in a wills variation context, the parties' financial circumstances are a factor in the court deciding whether, like Alyssa was saying, equal is not necessarily equitable. So you might have 3 children, but one of them inherited $3 million from grandma or some other relative, and the other kids got nothing. Mm-hmm. The court's going to take that into account when they decide what's fair from this estate.
So you say, well, you already have a pot of money, so you don't need as much, and the other 2 siblings will get more. Mm-hmm. It's interesting. It's quite organic, isn't it?
Absolutely. Every client is different. We see similar sets of circumstances repeatedly, but every client will ask for something different to happen in their circumstances, and every client's asset base will be structured slightly differently, and the relationships between the parents and the children are clearly different. So it really is entirely organic.
That's the voice of Alyssa Lockhart, partner of McQuarrie Hunter, and Leah Donaldson, associate, is also here from McQuarrie Hunter. When we come back, we're going to get into powers of attorney, representation agreements, and more on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.